Ses deneme. 1 2 3. Ses deneme. Ses deneme. Ses. Ses. Ses deneme. Ses deneme. 1 2 3. Ses. Ses. Ses deneme.
Ses. Ses.
Ben de mi
Ses deneme.
konuşayım? Ses deneme. Ses deneme.
Ses
1 2 3.
deneme.
Ses deneme. Ses deneme. Ses. Ses.
Se.
Ses.
Se.
Dokuz on ses deneme ses kontrol 1 2 3 4 5.
Dediğiniz gibi insan kafasının aslında bir
Başlatıyorum. Burada ben vereceğim şimdi. O zaman. Tekrar merhaba. Öğleden sonranın ilk oturumu olan dezavantajlı.
Hello everyone. We are doing this first session of the afternoon, Disadvantaged Groups, Access to Justice, Problems, Solutions and Examples of Good Practice. Dr. Nava Öztürk will be moderating. There is a change in the program. Damian Tatic will be speaking first. I would like to welcome everyone to the afternoon's first session. I would also like to say that I'm very happy to be in this conference. I watched the first session on YouTube and I benefited from it very much. And as Professor Chidem said, I think also that the best moderator is the moderator who speaks least. So I will go directly into the deliberations. Dr. Damian Tatic will be making the first speech. He will be speaking online, and I would like to give you some information on him. Damian Tatic served as an expert member of the United Nations Committee on the Rights of Persons with Disabilities from 2011-2019. He served as Vice Chairperson of the United Nations Committee on the Rights of Persons with Disabilities in 2017 and 2018. Damian Tatic is legal expert of National Union of Persons and Disabilities of Serbia and disability activist working with numbers of Serbian DPOs. He was also consultant at different international organizations. He works and teaches at Belgrade University and in the Department of International Affairs of the University of Belgrade. He did a PhD on the protection of human rights of persons with disabilities. He has published several books and many articles, and he lectured at seminars and conferences at Serbian Academy of Sciences and Arts, Universidad Carlos III in Madrid, European Rights Academy in Trier, the University of Basel, Judiciary Academy of the Czech Republic in Prague, the Judiciary Academy of Turkey in Ankara, and in Austria, Albania, Belgium, Bulgaria, Bosnia and Herzegovina, Croatia, Finland, France, Macedonia, Georgia, Malta, Latvia, Poland, Spain, Turkey, and the US. We will have a limit of 20 minutes in this session for speakers. We will also have 20 minutes for a question and answer session. I would like to turn the floor over to Damian Tatic.
Thank you so much. I hope that everyone can hear me well. And it is a great honor. And challenges that are even greater for passengers with restricted mobility because the number of support staff at most airports is much smaller.
Ses gelmiyor. Yani efendim maalesef kulaklığımıza ses gelmiyor. Dışarıdan gelen sesi de tercüme etmemiz oturan insanlar gibi biz dinlemiyoruz. Biz kulaklıktan dinliyoruz. Dolayısıyla duyabildiğim şeyleri tercüme edeceğim ama şimdi kulaklığa verilmesini umuyoruz. Genellikle sonuçlarıma başladığım gibi başlamak istiyorum. Kendimize şunu hatırlatalım istiyorum. İnsan hakları herkesin haklarıdır. Dolayısıyla engelli insanların da insan hakları vardır. Çoğu durumlarda engelli insanların spesifik hakları yoktur. Ama haklar için
Today I will talk about those specific measures needed to ensure access to justice for persons with disabilities. Convention on the Rights of Persons with Disabilities is a specific treaty, human rights treaty, that was adopted.
Engelli insanlar üzerine uluslararası sözleşme 2006 yılında Birleşmiş Milletler tarafından kabul edildi. Bir de protokolü vardır. 185 devlet
Recent counts and 100 state parties to the optional protocol. It is interesting to note that beside 183 member states of the UN, we also have, due to its specific status at the General Assembly, State of Palestine is one of the state parties. And for the first time, regional organization, European Union is a state party to the convention. All member states of European Union are also member states of the convention because of the division of competences between EU and its member states. So once again, as I've said, and I'm linking to that idea that human rights belong to everyone, the purpose of the convention is to promote, protect, and ensure full and equal enjoyment of full human rights and fundamental freedoms by all persons with disabilities and promote the respect for their inherent dignity. Among the numerous civil and political, economic, social, and cultural rights which Convention deals and prescribes specific measures, Article 13 deals with the topic of today's conference, access to justice. So, Convention, of course, says that state parties are under obligation, under duty to ensure access to justice under equal conditions for persons with disabilities, including to providing age-specific and procedural accommodations. Now, when we talk about procedural accommodations, it is important to highlight that we're not talking about reasonable accommodations. Because if for reasonable accommodations, a cost of accommodation is taken in account, but procedural accommodations, no. I here quote my dear friend and colleague, former vice chairperson of the committee, Mr. Kumara Punandi from Mauritius, who was always insisting that this means that access to justice has to be ensured no matter what it costs. So if we talk about physical accessibility of the courts, public prosecutor's office, police stations, they have to be made accessible for people who are, for example, wheelchair users. Information in judiciary proceedings must be accessible for blind persons in accessible formats, for deaf with provision of sign language interpretation, for persons with intellectual disabilities. It has to be done with the easy to understand, easy read language that is used. I always like to compare convention to a big jigsaw puzzle where all the pieces fit together. So all different articles are read together. Here we have a link between Article 12, legal capacity, and Article 13, access to justice. If a person with disability is under guardianship, he or she probably very often faces procedural barriers and doesn't have capacity to participate in the proceeding. And of course, committee is advising and recommending that that should be abolished. it is also very important that there is a constant awareness raising about the access to justice, training for professionals working in judiciary system. And beside judges and public prosecutors, Convention also explicitly highlights police staff, prison staff. So training like this one is very, very important. And I'm very happy to be part of it, for sure. Well, as you are aware, Convention set up Committee on the Rights of Persons with Disabilities as a body that monitors how different state parties implement Convention. And so far, they have covered close to 100 initial reports and second periodic reports. In 2019, Turkey had presented its initial report, and the committee reviewed it, expressed its concerns, and made specific recommendations. I think that most of the participants are from Turkey, and I guess you probably know about these recommendations, but I think it would be useful still for us to remind ourselves about it. So committee was concerned that not all court buildings are accessible for wheelchair users and people with restricted mobility. That blind persons face challenges in receiving information in judicial proceedings in accessible format, braille print. Also, deaf persons who are parties to court proceedings sometimes have challenges with sign language interpretation, to which they have the right. Free legal aid is a very important aspect of access to justice, and the committee was concerned that there isn't sufficient free legal aid for persons with disabilities. I'm very, very happy that the Bar of Turkey is part of this conference, and I'm sure that there will be some very interesting and useful alliances forged. And maybe later, when I finish my presentation, maybe you can share with me a bit more of information about it. Definitely, another concern which committee expressed was that the relevant laws prevent persons with some types of disabilities from becoming judges and public prosecutors. Committee, of course, made recommendations that barriers have to be removed and courts have to be made accessible, that information in accessible format has to be provided to blind participants in judicial proceedings, signing language interpretation to deaf participants in judiciary proceedings, free legal aid, and also, very important, change of laws that prevents persons from disabilities serving in judiciary system. Now, under the optional protocol, once all the national legal remedies are exhausted, individual can submit a complaint to the committee. Committee is not quasi-court. Its recommendations, its decisions are not mandatory, but recommendations should be implemented in good faith. That's one of the fundamental principles of international public law. So, over the years, it had several cases relevant for access to justice. In Makarov and Makarova versus Lithuania, we had Mrs. Makarova who got injured in a car accident. And unfortunately, she became person with disability as a result of that. Court appointed her a legal representative, but that legal representative wasn't doing anything at all for her. She wasn't consulting her. He wasn't respecting her will and preferences. He didn't even inform her about it. Maybe because the proceedings ended against her. Maybe the result was that was the result of fact that person who caused the car accident was a local tycoon. Or that didn't really show up in the court, but I'm just wondering, because Makarov is a Russian name, seems that Makarovs were members of the ethnic Russian minority in a Baltic state. Maybe that was also another reason why they were having not a favorable treatment. Anyway, committee found that there was violation of Makarov's right to access to justice and recommended that all the legal costs they had be recompensated by Lithuania to them, and that they take measures that they never allow that type of mistake. They change legislation and they make sure that legal representative really respects the wills and preferences of persons with disabilities whom he or she is representing in a case. There were 2 cases against Australia, and those were very interesting because in countries which have a jury system, jury duty is very important. We had 2 deaf Australian individuals, Mrs. Beasley and Mr. Lockeray, and they were summoned to serve as jurors. And they needed to have support to serve as jurors. She needed sign language interpreter in Australian Sign Language, and he needed simultaneous stand-up captioning. In both cases, court authorities refused them the right to be jurors, and they raised very important issue, the confidentiality of jury duty. Committee found that it was, of course, committee also believes that confidentiality of jury duty is very important, but it is erroneous. Just as a juror makes a solemn declaration, swears to uphold confidentiality of proceedings, and can be held accountable, could be sued, even criminally persecuted if he reveals some confidential facts. The same can be done for the sign language interpreter. The same can be done for the stand-up captioner. And I'm sure because of that, committee recommended to Australia to recompensate all the costs, legal costs to Mrs. Beasley and Mr. Lockeray, and that they amend their laws and they enable deaf jurors to serve on jury duty next time they're summoned. For the very end of this presentation, I covered some of the cases that happened over the last couple of years. There were access to justice was not the principal issue, but it appeared in the communication. We've had Ferrero Mantils against Spain. Here the case was a 92-year-old man with disability was about to be expelled from his place of residence because of the debts. And he claimed that, among other things, his access to justice in the proceedings has been violated. Unfortunately, Mr. Ferrero died during the proceedings, and as it is a practice in the committee discontinued the complaint. So it was never able to assess if there in fact were any violation of the access to justice. Then we had the case of Koch versus Austria. Koch is a young deaf woman, and she wanted to be educated in Austrian Sign Language, and that Austrian Sign Language, rather than German, is recognized by education system as her first language. And she had 3 arbitrations with different 3 education institutions. And she wasn't satisfied with the outcome, and she claimed that her access to justice was violated. Committee found that there were no violation of Article 13. And I think that was wisely. Of course, when a lawyer is representing somebody, he or she should do everything for his client. But it's not a good strategy to make a big list of alleged violations. And also, you cannot say that your right to justice has been denied just because you're not satisfied with the decision. It has to be much deeper, and it has to be more serious than that. There was also a case of Zadam against Sweden, and he was Afghani national who applied for asylum and claimed that in the process, because he was denied, his access to justice was denied. And committee did not focus on that, and I think that's good, because if a lawyer comes up and says, my client is not satisfied with the outcome of a judicial proceeding, and claim that that amounts to restriction of the access to justice, that's almost an abuse of right. And I really think it's very bad strategy. And I'm happy that committee realized that those are not access to justice. That access to justice is much more serious thing that when, for example, court is not accessible, when a person cannot receive materials, when legal representative is not consulting him or her, respecting her wishes, his wishes, when there is no sign language interpretation, all of those things are really violation of the access to justice. But if you're not satisfied with the court's decision, that's not automatically, it could be if there were miscarriage of justice, but not automatically. So I hope that all these information is very useful. And maybe later on, it would be interesting for me to hear when I was talking about the recommendations of the committee to Turkey, if I can get some feedback from you about if those were implemented after 2019. I know that the pandemic put a stop to many things, but maybe something has happened. And I thank you for your time and attention very much, Teşekkürler. And maybe because unfortunately I will be later on have to leave you maybe even before the end of the session because of the arrangements with my personal assistants and moving of the schedule. Maybe if you have any question or two, if that is all right with the moderators, maybe you can pose them now. If not, you can send it in chat and organizers will send it to me by email and I will try to the best of my knowledge to respond to those questions. Once again, thank you so much for your time and attention.
Doktor Tatiç'e çok
We would like to thank Dr. Tatić for his comprehensive presentation and for respecting the time. I would like to send my special thanks. And as he said, he has to leave. And if you have questions for him, we can have the questions right now because he finished 3 to 4 minutes early than scheduled. So if you have questions, you can ask them now. Yes.
lütfen.
Yes, go ahead. Mike, please.
Well, thank you for this wonderful presentation. My question is, what is United Nations stand on persons with disabilities is getting restricted legally with guardianships or conservatorships? How does that impact disabled persons' access to justice, and what is United Nations doing to change it? Thank you very much.
Doktor Tatić bizi duyabiliyor ise eğer, biz şu an kendisini salonda duyamıyoruz. Eğer bizi duyuyorsa rica etsem sorun...
If you hear me, can you wait until the end? Because we cannot hear you any longer.
Of a challenge because I think
Sorun da o.
asked a question in English and I was receiving translation in Turkish, so I did not hear the original question. If I could ask kindly the interpreter to repeat it now in English so I can hear it and then I can understand, because I'm all the time on the English channel.
Okay, sorry about that.
Yes, I can hear you. Could you please repeat the best of your remembrance what the colleague asked? Yes, thank you so much.
Tekrar Türkçe sorabilirim karmaşa için.
Hayır ama o.
Biliyorsunuz ki engelli kişiler yasal olarak vesayet ya da vasilik gibi mekanizmalarla... Gitti. Bana bir daha sorun dediler de. Az önce... pardon. Hani az önce de biri Türkçe sorun dediği için çok pardon. Briefly, my question was about, disabled persons getting legally restricted with the mechanisms of conservatorship or guardianship, and this sometimes can impact to access to justice for them. And what is United Nations doing, and what are the regulations on those matters to abolish conservatorships maybe at a large scale and improve the disabled people's access to justice? Thank you very much.
Thank you very much. This is a really good and relevant question. Yes, recommendation and jurisprudence of the committee is very consistent in that way. That guardianship system should be replaced by a system of supported decision-making. Of course, in practice, for a person who requires high level of support, that may be challenging, but still it's not an excuse. It is true that in most of the countries, I believe Peru is the only one that completely abolished guardianship. Some European countries like Hungary and Austria introduced supported decision-making, but unfortunately they still have thousands and thousands of persons with disabilities under guardianship. I think it is important to see how best to really enable a person with disability not to be an object of law, but a subject of law, and that his or her will and preferences are taken in account, that they are really authentically expressed, and that they are taken in account when there is a legal process in which he or she is participating. Of course, there is a need to change the civil code or family code or any other law that sets up the system of guardianship for that. And it will take time, but it's important to take the first steps. I hope that this at least gave you some idea in which direction should go. Of course, the committee always recommends very strictly, and there were specific recommendations to Turkey also about the changes of, I believe, civil code pertaining to abolishing of the guardianship and introduction of substituted decision-making.
Çok teşekkür ediyoruz Doktor Tatiç'e.
Thank Dr. Tatiç.
Başka bir soru yok. Tabii buyurun.
Merhaba, Bayram Oran ismim. Eski Türkiye Köylüler Federasyonu Genel Sekreteriyim. Şimdi Sayın Tatiç dedi ki Türkiye'de bazı mesleklere engellerin girişinin engellenmesi vardı eskiden. Şimdi de var mı? Sayın Tatiç'in sorduğu soru 2018 yılında Engelli Hakları Komitesi'nin Türkiye'ye sorduğu esaslı soruların başında geliyordu. Aynı konu henüz olduğu gibi duruyor. Örneğin hakim, savcı, kaymakam gibi mesleklerde engellerin alınması şu anda söz konusu değil. Türkiye'de şu anda engelliyken alınan hakim, kaymakam yok. Ama hakim, savcıyken
people who are appointed, but when a governor in office undergoes an accident and becomes handicapped, that's a different matter. Thank you for your contribution, says the moderator. But with respect to what has been said, there was a legal arrangement for blind people or people with visual disabilities to become, in order to make it possible for them to become judges, public prosecutors or lawyers, but still no one has become one. We thank Dr. Tatiç once again for his very interesting and important contribution to the presentation, and thank you for those who contributed to the discussion. Now we go over to the second speaker. Our second speaker is the Dr. Duygu Hatipoğlu Aydın. She is from Hacettepe University, and she will be speaking online too.
She graduated from Ankara University School of Law in 2003.
Yaptı. 2013 yılında Ankara Üniversitesi Sosyal Bilimler Enstitüsü'nde Kamu Hukuku Yüksek Lisans Programını, 2018 yılında Kamu Hukuku Doktora Programını, Hukuk Felsefesi ve Sosyolojisi dalında İşçilerin Hukuk Deneyimi başlıklı tezle tamamladı. Hukuk ve toplum ilişkisi, farklı grupların hukuk deneyimleri, toplumsal cinsiyet ve hukuk, dijitalleşmenin hukukla ilişkisi başlıklarında çalışmaları bulunan Hatipoğlu Aydın, halen Hacettepe Üniversitesi Hukuk Fakültesi, Hukuk Felsefesi ve Sosyolojisi Anabilim dalında öğretim üyesi olarak çalışmaya devam ediyor. Ayrıca TÜBİTAK bursuyla Linköping Üniversitesi
Had a TÜBİTAK fellowship, and she is working on immigrant women, Turkish women living in Sweden, and she is a visiting academician in Sweden. We will listen to Professor Duygu. I would like to first ask her if she likes to share her screen. Yes, I will be sharing my screen, yes.
Kadının yüzü.
I guess you can see my screen. Hello. I will be talking about the access to justice by women. First of all, I would like to thank Association for Monitoring Equal Rights, and I would like to thank Atılım University and Union of Bar Associations of Turkey, who participated in the organization of this event. And content-wise, the conference is very rich, and I'm very proud to be a part of this conference. And I heard the introductions, and an area of interest is the law and court experiences of different groups. And today I will be talking about women's access to justice. This speech will depend on the theoretical and practical work I have done over the years. I will talk about what women's access to justice means, and the obstacles and solutions that may be seen in the process. Access to justice is a very important issue for us lawyers, both in theory and in practice. Because of their positions in social life, women can be considered as a disadvantaged group that should be specifically evaluated in the processes of access to justice. There is much that can be said about positive arrangements in law and regulations, especially in the international arena, and also regulations in national law. However, first of all, I would like to mention that access to justice is not only a matter of law or legal debate. The design, adoption, and application of legal rules take on meaning not within a self-appointed legal system, but within the broader framework that encompasses it. Why is access to justice not just a regulatory problem? Because even the most equitable and impartial legal regulations, in terms of content and technique, can create various grievances by combining with other constraints and obstacles. we see that some features and assumptions inherent in modern law are at the forefront of the early debates on the concept of access to justice. First of all, modern law, especially the professional professions, has the characteristics of being unified in the court system and being formal and positive. Secondly, modern law, by creating abstract legal subjects, has taken to the possession and ownership of these rules, realizing access to official courts as a universal right. In modern legal debates, the establishment of law is synonymous with justice. However, daily life practices have shown that fictionalized situations do not always provide equality or justice. Particularly in liberal societies, serious inequalities lie on the basis of formal access to justice and formal equality. Women's access to justice deserves special scrutiny because of their social position, application to judicial authorities, access to legal information, economic concerns during litigation processes, urban transportation opportunities, and like. In general, inequality in processes such as poverty, education, participation in daily life, and urban life can be seen as factors that differentiate women's positions in access to justice processes. The fact that the resolution of disputes in daily life is foreseen with legal mechanisms based on the principle of equality does not always guarantee a solution. However, it can also deepen insolubility and forms of inequality, such as gender. The situation of women facing a legal problem in the face of the system may render the impartial regulations of the laws dysfunctional. I want to get into the details of this, and in accordance with the principle of equality, which is one of the foundations of modern law, everyone is equal before the law. As the principle of equality before the law shows, categorical entitlement, that is, the categories created by impartial and non-discriminatory regulations and access to justice, may remain artificial for women. And the difference between men's and women's daily life experiences may cause such neutral regulations to result against women. In other words, the equivalent of the principle of equality in daily life can be inequality. Gender inequality as a form of inequality is one of the important topics of discussions in the processes of access to justice. As a short example, I would like to talk about how the public-private dilemma is a situation that leaves women behind in their access to justice processes. Comparing the budgeting in criminal and civil proceedings, we can say that legal aid service in criminal proceedings is higher than in civil proceedings that regulate the private sphere. In criminal proceedings, compulsory defense is quite common, but the application of legal aid in civil proceedings is both optional and difficult to attain. In cases where victims are women, perpetrators and men, and the parties are related, violence in the private sphere becomes public, and it results in the perpetrator's legal aid representation, while women's requests for representation or protection remain private. For example, while the victim of domestic violence cannot benefit from compulsory defense in criminal proceedings, the accused man can be directly appointed as a lawyer. In the context of the principle of equality, both the equality and difference of women and men empower men as a standard against which women are compared with men. Even if women are seen as the same as men, the criteria for comparison are sexist. In this case, it can be said that the equality on paper in the processes of access to justice is deteriorated by different forms of inequality in the society. Definition of what access to justice is and discussions about it are very important at this point. It is necessary to understand access to justice as a process, not as a problem-solving oriented or legal aid mechanism in the system, which is more or less supporting people in the system. In addition, while identifying the obstacles to access to justice and suggesting solutions to them through law, the issue is not only about the law. There are some structural constraints, such as the secondary position of women in society, poverty, education level, and the legal system is one of these in terms of both norms and practices. It must be admitted that it is not free. While offering solutions, issues that are claimed to be egalitarian or neutral for each disadvantaged group need to be reconsidered. I would like to give a brief example. While barriers to access to justice are common to various groups, women might suffer from these barriers more often and might have a hard time overcoming them due to other areas that produce inequality. For example, poverty is a considerable burden. Poverty is an obstacle to access to justice for every group in places with high judicial fees, but it can be said that women's poverty increases these barriers further. Again, access to justice venues can be a general problem of access to justice, but when it comes to women, for example, not working, not having an income, financial dependency, or not leaving the house due to reasons such as working at home, child or elderly care being left to women, as well as neighborhood pressure, these become specific factors that restrict women's access to justice. Of course, this can be considered in different ways for many disadvantaged groups. I am referring to women within the scope of this presentation only. I would like to address the barriers to women's access to justice at various stages and try to summarize it under three headings. One, awareness, application process, and accessibility. And first of all, in order to talk about women's access to justice, women must have rights on certain issues. Women should have rights so that they can claim rights through different mechanisms and take action for their rights. Therefore, first of all, rights must exist. And having rights is not enough by itself, because the lack of information about women's rights is an element that affects women's access to justice. In general, it can be said that women do not know their rights. Information channels about their rights or what they can do are also sources such as social media, TV programs, neighbors, social environments, and experiences of other women. But this indirect or individual experience information by itself is not enough to reach the right information. The most important thing that feeds this lack of knowledge is the general education level of women. As the level of education increases, the level of knowledge about rights also increases. Women may not know where to go when they have problems, but beyond that, the mechanisms they will resort to are almost non-existent. In this sense, we can say that there is either no social support mechanism or that the existing ones are very weak. Under this heading, difficulties in assessing judicial authorities can be mentioned. These difficulties can be institutional or physical. When we say institutional, we must first say that when we talk about access to justice mechanisms, we are not talking about the courts as the first step. Police, gendarmerie, and police take the first place in solving the problems experienced by the public force. And for example, for women who are exposed to domestic violence, their experiences with the security forces can experience their grievances. Institutional access is a serious problem if the public prosecutors who deal with events such as violence, abuse, and harassments and accept their complaints, and the judges who listen to the actions adopt the general insensitivity of the society towards a woman, or if they act with certain prejudices, have discriminatory judgments and sexist perspectives, and reflect this in their practices. I think this is particularly important because on the one hand, law may be the only way to solve a problem, and otherwise the legal order would not allow justice to be established. So the male-dominated state throughout the justice institutions, including the prosecutors and the police, a male-dominated mentality as well as male officials, especially in matters of domestic violence and rape, along with fears of shame or stigma, can hinder women's complaints or complicate the follow-up of the process. Physical access to judicial institutions is also a problem for women. We can say that women's practice of going out on the streets is limited in Turkey. Women's living spaces are houses or neighborhoods. Their relatives might not allow them to go. Women's freedom of movement is restricted due to reasons such as housework, and this is accepted as a natural norm, and women leave the house to resort to various mechanisms in the face of a legal problem. It becomes a serious burden for women to spend money on their own and face other social pressures and restrictions. Poverty, working at home, limits their participation to legal processes. Transportation difficulties, the fact that women are completely dependent on the perpetrator and similar situations create problems in the processes of access to justice. In this case, women's access to or frequent visits to the place of justice have a different cost than financial costs. The second heading is options and quality in justice services. This has been mentioned in the morning session as well. In Turkey, the mediation system has been made compulsory in many areas, and alternative dispute resolution mechanisms have been developed in some way. However, the courts still remain the main place of solution for legal problems. In order to use the courts and to contact the court, it is necessary to go to the courthouse. Yes, there is a tool like UYAP, but as a citizen, its use is limited. And if you have an electronic signature, a lawsuit can be filed. Other than that, it helps to see the stages of the case only. For the use of UYAP, there will be internet and digital literacy. Therefore, going to the courthouse is a necessity, but it is still a problem. Not only because women's curfew practices are limited, also, as you know, there are many courthouses in Ankara, and women may not know what is going on in these courthouses. And the working hours of the courthouses are not suitable for women. A woman who will follow her own case at the courthouse or listen as a witness in another case has to take time off from workplace if she works. And this is not something that can be permanent. At the same time, for a woman who will come to the courthouse with, let's say, her child, the inadequacy of childcare facilities is another constraint. The delays in the hearings, the delay of the hearing scheduled at 10 a.m. to the afternoon, for example, creates a very serious problem for women who take leave from the workplace. The inadequacy of women in consultation and representation is another subtitle. First of all, legal aid services are insufficient. There are many documents required to obtain legal aid from the courts within the scope and to apply to the legal aid services of bar associations. Collecting these documents is a task in itself, and women have to go and deal with many different institutions. Of course, this method can be mitigated over the years or depending on the location, but there are activities that will increase the power of bar associations in legal aid services. It is still possible to talk about a general inadequacy. And legal aid budgets are low within the judicial budget. Court fees are high. There is no need to elaborate on this, but due to poverty, not being able to pay the fees during the ongoing court processes, women might give up seeking their rights in court. The complexity and incomprehensibility of legal language is another constraint. The litigation process is difficult for women to pursue by themselves. Why women may be more disadvantaged than men in accessing money and social networks because they cannot afford a lawyer due to economic reasons and because their social networks are weak. Of course, the lack of education is also a factor, but the complexity of the legal language and complexity of the procedural rules are also affecting. Here we see that the problem-solving of justice mechanisms is reserved for legal professionals. The way to overcome this is to expand and facilitate legal aid opportunities. There are also problems in the implementation of court judgments. It is not enough to win a case in Turkey. There are many women who have been subjected to violence or killed in the divorce process, or they are entitled to alimony for their child, but they have to go through many other stages in order to collect that alimony. We always see that court decisions, although satisfactory for a woman, can remain on paper, and then the implementation of decisions can be a problem in women's access to justice. The ineffectiveness of the protection or precautionary decisions taken by women who have been subjected to violence is also an important problem. Many women are protected from their partner's violence despite being suspended repeatedly. A favorable decision from the court might not always be enough to ensure justice. In women's access to justice, the lack of protective mechanisms, as well as lack of social support mechanisms, such as shelters, reduce the effectiveness of the judgments. And thirdly, I will talk about the experiences in legal processes. The slow pace of litigation is a serious problem. Women want to divorce, they have custody problems, or have problems with inheritance. As the trial process is very long, this means a violation of the right to a fair trial. The low number of judges and prosecutors and the high workload have consequences. The first is that the lawsuits take a long time, and the second is that women's legal problems are not taken as seriously, and this brings together poor quality. Another problem, as stated by women, is the low number of female judges and prosecutors. As a professional profession, we can say that the highest level of numerical equality in terms of men and women among lawyers can be seen in the profession of law. There is no equality between judges or prosecutors. The expectation of women is to be understood, and women feel that they can express themselves better to women, and they cannot do this comfortably in front of men. Women cannot be judges everywhere, but at least judges, prosecutors, and lawyers should receive gender training. And lastly, and this is a general problem, by the way, the possibility that the decision makers can be biased. Women may see themselves as weak in social life, and they might also be accustomed to this. However, this creates a general distrust to the judicial system, and this affects the use of justice mechanisms. As a result, various assumptions of modern law, such as equality before the law, universality, fairness, including access to justice, may work against women in the processes of access to justice. Access to justice should be considered as a process. It is necessary to act by considering how it works for disadvantaged groups, how existing laws are interpreted and applied, and considering the solution from a broader perspective, without reducing it to just a legal regulation problem. Thank you very much for listening.
Zaman konusundaki hassasiyetiniz için ben şimdiye kadar çok şanslı bir
I'm a very lucky moderator. I have been one up until this point, and so I would like to thank you once more. Professor Tapanoğlu will be with us until the end, so you can ask her your questions in the question and answer session. Now let's go over to our third speaker, who is Yasemin Öz from Chaos GL. She will be talking about human rights of LGBTI+. She was graduated from Ankara University Faculty of Law in 1997. She has been a human rights lawyer and defender, feminist and LGBTI activist for 27 years. She actively works with LGBTI organizations and women organizations dealing with domestic and sexual violence, trafficking and supporting of women candidates. She received the Felipe de Sousa Award of IGLHRC in 2013. She was accepted to the Sakharov Fellowship of the European Parliament 2018. She is the co-founder and vice chair of CAOS Gay and Lesbian Cultural Researchers and Solidarity Association, founded in 1994. Pınar Selek, she has been working on the international. She has been the international spokesperson for justice for the Pınar Selek Committee since 2009. Between 2015 and 2019, she was a member of UN Women, Europe and Central Asia Civil Society Advisory Group, and selected to UN Women LGBTI Plus Informal Reference Group in 2017. And she has finished the certificate program at Venice University, the International Human Rights Center, and she is a member of the LGBTI plus committee of the Istanbul Bar Association. She has written Turkish articles in Turkish and in English. This is a very comprehensive scope, comprehensive biography, and now I turn the floor over it. Even I was bored, and I don't know what people thought in the audience. LGBTI have to work a lot in order to win human rights. First of all, I would like to thank the Association for Monitoring Equal Rights and the Union of Bar Associations of Turkey and Atılım University for having prepared such a comprehensive program and brought people together on such important issues. I would like to take a picture of the human rights of LGBTI in Turkey. Well, we have been working on this for a long time, but our time is limited, and I understand very well the time sensitivity of the moderator. First of all, let me say the following. In Turkey, whether negative or positive, there are not any serious provisions in the Turkish legislation. There is nothing that supports the human rights of LGBTI. There's nothing really that negatively approaches the LGBTI plus rights. Since the Ottomans, this has been the case. In many countries, there were bans, prohibitions of LGBTI practices. In countries where the West occupied, there were sanctions against LGBTI plus, but both during the Republican period and before, there was nothing in Turkish legislation. It's as if they approached it as if this did not exist. Well, we have a lot of gay and trans women, and they are invited to the banquets of the presidents, etc., etc. But no gays on the street. Don't talk about it. And this has a long history, because even under Ottoman times, there are so many different sources that talk about LGBTI. The Iranian president said we don't have any homosexuals in Iran. Apparently, we have in Turkey. Well, I'm not very much interested in this, of course, but now this leaving everything to the private sphere, of course, has its positive sides in the sense that you're not criminalized immediately because LGBTI plus. But on the other hand, because there's nothing that arranges your rights, all the homophobic, transphobic, biphobic prejudices in society, 7/24 in every sphere of life can confront you and leaves you helpless when faced with the institutions of the state. This is an ongoing form of discrimination because there is no legal arrangement. Of course, there are cases that go to courts or the administration regarding the LGBTI plus, but that leaves the margin of discretion to the judge, and that depends on their perception, personal perception, their personal worldview, and so we receive all the administrative and judicial results as a result of this kind of, capricious situations. And there is no monotony in cases. One court gives a different decision from another because, with respect to jurisprudence, the High Court of Cassation in its grand chambers did not have any decisions which could be used as jurisprudence. There are some High Court of Cassation or the Council of State kind of decisions, which may have worked as jurisprudence, but not really. And with respect to seeking one's rights, they can only go to the administration or to courts. And we are forced to create our own legislation by going to court ourselves. Are there any provisions in Turkish legislation about prohibition of discrimination against LGBTI plus? No. The Article 10 of the Constitution, Article 5 of the Labor Law, and Article 122 of the Turkish Criminal Code do legislate for the ban on discrimination, but these don't really cover the question of LGBTI plus, their rights, because there are no other provisions in Turkish legislation concerning LGBTI plus. So when LGBTI plus are discriminated, say, with respect to the labor law or any other kind of legislation, this leaves everything to the discretion of the judge. And then with respect to Article 122 of the Turkish Criminal Code, there is the ban on discrimination with respect to access to goods and services. But then because the LGBTI plus are not defined as a group that is discriminated against, you cannot use this for LGBTI plus in any case. Because criminal code, the criminal law cannot be expanded on the basis of comparison as opposed to this civil law. The most swift way of providing for these kinds of provisions, of course, is to go for a constitutional and legislative activity. But today we can receive some support from political parties, but when we first established the LGBTI movement in the early 1990s, of which I was one of the founders, I was a student then. It was a matter of fear, really, and trepidation. Well, don't come out in your workplace, don't come out in your family, don't come out on your street. For those who went on the media to talk with your identity clearly defined, there was danger. Well, we were, of course, afraid, but we started the whole struggle with great resolution. Because we're very sure that if you don't fight for your rights, you never go anywhere. Because we had the opportunity of the chance of observing other countries' historical development. Because in Turkey, this whole thing started very late. But I think we have covered great distance. We may not have reached a positive point because there was a very conservative government, but then if I were told that we could organize 100,000 crowd for the Pride Day, I wouldn't have believed them. But we've come so far. And then in the laws and in the constitutional law, there are certain concepts that may really be used for the LGBTI to be discriminated against, to act in a hideous manner or to act against the precepts of public morality, etc. What do you mean by morality? What's the beginning? What's the ending? And where are the boundaries? What is morality? What is immorality? There is such a large margin of discretion here for the judge that the person that hands down the decision will only apply this provision the way they perceive it. Of course, this reflects very badly on the rights of the LGBTI+. When we started out the movement, this was also a struggle in the field of law. We were trying to create new law. When we first started the struggle, with respect to hate murders of LGBTI+, Turkey was first in Europe and very much ahead around the world when you compare to other countries. We struggled on this. And so the positive change came about because we struggled against this. This is not a matter of, the state preparing new legislation or a serious public policy being adopted, etc. There is nothing. There are public policies nowadays that violate the rights of LGBTI+. For instance, during the Gezi uprising of 2013, the LGBTI were very prominent. And then there was this failed coup in 2016, and the repression on the society really increased. There was the state of emergency declared, and then the Pride marches. The governor's office of Ankara stopped without, sine die, without any ending in sight, all the actions of the LGBTI. Even in the law of state of emergency, there is a limit on such bans of 6 months. But this was, without any limit. I don't think this is for nothing. Had the LGBTI plus stayed home, had they not marched 100,000 people on Pride Day, this would not have been seen as a challenge to the conservative worldview. So once you do this, you also provoke the reactions on the other side. Let me also say the following. The fact that there is no discrimination that prohibits discrimination. We have been writing reports on the question for years, and we compared the different years so as to see whether it increases or decreases the violations. Well, access to services, education, health, travel, these kinds of fundamental freedoms should really become free in practical terms, not only in theoretical terms. And of course, this really deprives us of many social rights, like pensions or visiting someone, an LGBTI plus in hospital. And this, of course, is very disadvantageous for LGBTI couples when compared to heterosexual couples. They cannot enjoy the protection of any kind of relationship. And the Turkey is, I think, well, Hungary is competing here on this question. Turkey is first in Europe with respect to hate murders. Well, if murder is in the on the agenda, then of course other freedoms cannot even be spoken about. There are two arrangements. One is Article 40 of the Civil Code. This is the transformation from one sex to another, transition. If you are not productive in as gender the gender reassignment surgery will not be practiced if you are sterile in terms of reproduction. What is the relationship? Well, nothing I can think of, but all these courts demand different kinds of documents here. We never see them acting in unison. And then there is the provision regarding the army. All the three armies or branches of the army have their health conditions for military service. There is a provision there that says that people who have some kind of disorder of sexual behavior will not serve in these three branches. Of course, what those disorders are never discussed. Violations have been increasing since 2013, definitely since 2015. Well, there is a conclusion, and this we have voiced in our report. Public authorities, in particular the highest levels, the Ministry of the Interior and the President's Office, really create a lot of violations. And from torture to unjust detention, very different kinds of violations. Each time we go to court, and we do really have the decisions for prohibition or ban cancelled. Now, I had the 2022 ban cancelled. Well, once this has been determined determined as a violation, I should be able to do in that area what the court has decided for, but no, they bring forth another one immediately. Well, as in certain Catholic countries where religious leaders did the same thing, one of the ministers said that COVID was a result of LGBTI practices. And then the targeting of LGBTI during the demonstrations. And of course, the reason for the cancelling by the president of Turkey's subscription to the Istanbul Convention was shown as the LGBTI plus. The Istanbul Convention does not say anything special LGBTI. It says whoever they are, protect them from violence, and that's it. Well, you haven't done anything for the LGBTI anyway, so why, abandon the allegiance to the convention? So this is very much like the counterparts in Central Europe. In many countries, they copy each other's strategy. Well, I'm almost about to finish. They never say, when voting on equality between men and women in the United Nations, in Russia, the Muslims of the Middle East, the Muslims of Africa, and Catholic countries, Vatican, they all use their vote in the same direction. But they're all enemies of each other, but they come together very comfortably on the question of women and LGBTI. Very briefly, let me say the following. The hate speech regarding LGBTI plus we saw that the violations of the different rights increased twice. But when the public authorities come in, they change. But in certain other areas, they increase. And because of the arrangement of the Constitution, the Minister of the Family said we are really doing the best for them, which is not true, of course. It is, of course, possible to return to the Istanbul Convention, but if you can't, then of course you can always put this in practice in a de facto manner. Of course, we need consciousness raising and measures against discrimination. Let me finish in the following manner. For long years, I have been an LGBTI plus lawyer for long years. Tomorrow, I am candidate for delegate to the Congress of the Union of Turkish Bar Associations, but I'm the only one. I have been a candidate before, but always been the only one. There should be many more names. They should be part of the leading structures so that they can fight against all these violations of such fragile kind of community. Then we can only then progress human rights. Thank you for listening.
Yasemin'e çok
We would like to thank Yasemin a lot, and I had listened to her in the past. I had always been in the audience, and she is very fluent, and I forgot about the time limits. Thank you, Yasemin. Thank you very much for your presentation. Now, it is our next speaker, Mr. Mark Willers, from the European Center for Roma Rights, and he will be talking about the inequalities experienced by Roma people and travelers, and how the lawyers can help surmount these difficulties. Mark is a senior barrister and a member of Garden Court Chambers in London, and also a member of the Irish Bar. He specializes in planning and environmental law, public and administrative law, human rights and discrimination law, with a particular emphasis on the representation of Roma and travelers. Mark is also a board member of the European Roma Rights Center. You can follow Mark on Twitter, and his full profile can be viewed at www.gardencourtchambers.co.uk, and the floor is his.
Sorry. That's okay. Thank you very much for that kind introduction, and also for the very kind invitation for me to come and speak at this event, this very important conference on access to justice, and for the opportunity to address you about the ways in which lawyers can help tackle inequality and the discrimination that is faced by Roma and travellers in our society, and the ways in which we can facilitate access to justice for these disadvantaged communities. Now, I've written a speech which I'm going to be faithful to for the benefit of the interpreters, but my main key message today is that you as lawyers should get involved. These communities, as I said, are the most disadvantaged of communities. They need your support. As I understand it, there may be as many as 5 million Roma, Dom, Lom, Rom, in Turkey. The number of cases that they might need to bring to courts would be enormous. And yet, as I understand it, there are very few lawyers that are currently taking cases on behalf of Rom, Lom, and Don. My key message to you is get involved. Get involved with the NGOs. Get some cultural awareness training. Understand their cultures and their difficulties. Listen to them, and then act as their mouthpiece in court before the judges. Educate the judges. Take those cases. Take those arguments. And if you don't succeed, you may be in Strasbourg arguing the same point. And eventually, and it may take a long time, things may change, and change for the better. So as I was introduced, I'm a lawyer, I'm a barrister, a King's Counsel now. I was Queen's Counsel before the Queen's death. Now I'm King's Counsel. And I practice at Garden Court Chambers with about 250 other barristers. And we are self-employed, but we work collectively together. And I specialize in representation of Roma and travellers and have done so for now 35 years. I'm a trustee of a charity, one of these NGOs that represents Roma and travellers in the UK, and I am a board member of the European Roma Rights Centre, but I'm not speaking on their behalf. I'm speaking as a lawyer who hopes to persuade members of the audience here and elsewhere to take on these cases, although I'm sure they would endorse what I have to say. By happen chance, luckily, I was in Istanbul at a board meeting of the European Roma Rights Centre until yesterday. So I was able to take a train to Ankara, which was great. And I'm really glad, as I said, to be here. In the United Kingdom, the term Roma and travellers includes a number of different ethnic groups, including Roma who have recently migrated to Britain from Europe, and groups who have lived in the UK for hundreds of years, such as the Romany Gypsies, the Welsh Gypsy travellers, the Scottish Gypsy travellers, and Irish travellers too. And that term, Roma and travellers, also includes those people who have taken up a nomadic lifestyle, who we often refer to as new travellers. I'm going to say something about the prejudice and discrimination faced by Roma and travellers in our societies. They've faced prejudice and discrimination and hate crime in the countries through which they have passed and in those in which they have settled for centuries. But perhaps the most dreadful crimes committed against them were perpetuated by the Nazis in the Second World War. Quite rightly, we reflect on the terrible fact that the Nazis murdered 6 million Jews in the Holocaust. Yet there's often little mention of the hundreds of thousands of Roma and Sinti people that were also murdered by the Nazis in World War II, in what has become known in the Romany language as the Parajmus, or the devouring. The question always remains as to how the Nazis were able to get away with it, to commit these terrible crimes with impunity. Well, the Nazi propaganda machine played a very significant role by reinforcing age-old prejudices. Roma and Sinti were made scapegoats. They were blamed for the ills of society, dehumanized and characterized or stereotyped as antisocial thieves and vagabonds. And in fact, we've heard Yasmin talk about dehumanization of LGBT people, and it's the same kind of stereotypical dehumanizing propaganda that has worked for centuries against Roma. Well, the propaganda campaign worked, and the settled population was conditioned to believe what they were being told by what would now clearly be understood as hate speech. And there was very little opposition when the Roma and Sinti were rounded up before being transported to camps from which they would never return. Over 70 years later, the horror of the Nazi concentration camps is hard to imagine, but the widespread prejudice that Roma face in Europe, known as anti-Gypsyism or Romophobia, has not abated. It's an unwelcome fact of their daily lives, and with the growth of populist politics throughout Europe, such prejudice appears to be on the rise. Politicians throughout Europe continue to use hate speech against Roma, which in turn creates a climate in which racist violence is thought acceptable by offenders. And tragically, in recent years, Roma have been victims of violent racist attacks and murder throughout Europe. By way of example, in 2012, a Slovakian policeman shot dead, this is a policeman, shot dead 3 Roma and severely injured 2 more in a killing spree, which he said was motivated by a desire to solve the Roma problem. Whilst in 2013, 4 men with links to nationalist organisations were jailed in Hungary for 9 separate attacks on Roma and the murder of 6 people. Meanwhile, Roma continue to be forcibly evicted from their homes without the provision of suitable alternative accommodation. Their children continue to suffer segregation in schools, and they tend to live on the margins of society. Now, we're not immune from this hateful and discriminatory behaviour in the UK. Travellers and Roma migrants are amongst the most discriminated ethnic groups in our country, routinely targeted by those who use hate speech, both online and in other media platforms. Though travellers have been living in the UK for hundreds of years and in some rural areas of the country represent the main established and largest ethnic minority group, they remain amongst the most disadvantaged racial groups in our society, with low levels of life expectancy, high vulnerability to serious illness, poor mental health, high child mortality rates, and low levels of education attainment and literacy. And I have no doubt, even though I haven't read any reports about Turkey, that the same is true here. These inequalities are reflected in study after study, which show that traveller pupils had the lowest attainment of all ethnic groups throughout their school years and are more likely to be excluded from school than any other children, that the health status of travellers is poorer than that of the general population, even when allowing for other factors, such as variable socio-economic status and/or ethnicity. That shockingly, 1 in 5 traveller mothers will experience the loss of a child, compared with 1 in 100 in the non-traveller community. And that the life expectancy of Roma and travellers is 10 to 12 years less than that of the non-traveller population. In fact, I understand it's greater than that. Now, a key contributor to the poor socio-economic status of travellers in the UK is that thousands of families still live in caravans in accordance with their traditional way of life, but they have no lawful place to station them. Meeting the accommodation needs of travellers should be a relatively simple task. By way of example, it would only require the equivalent of 1 square mile of land to accommodate them safely and sustainably in their caravans. But in the face of widespread prejudice amongst the settled population, successive governments have done little to address the shortage of caravan sites. As a consequence, many travellers and their children have to reside on unauthorised encampments without permission, perhaps trespassing on other people's land, or on the roadside without proper sanitation. And they're often subject to continual eviction, being moved from pillar to post on the road to nowhere, without the chance to obtain proper health care or to educate their kids. Ethnic travellers are entitled to protection from discrimination under the equality legislation in the UK, but nevertheless, travellers still experience discrimination of the most overt kind. Just by way of example, there used to be a tendency for people who rented rooms to put up a sign saying no blacks, no Irish, no dogs. Those signs have gone, long gone, but we still see no travellers. And that is something that one sees not just on rented accommodation, but also in public houses, restaurants and bars. Indeed, the prejudice experienced by travellers living in the UK has been compared to that of the black people living in the American Deep South back in the 1950s. And it's also been characterised as the last acceptable form of racism in the UK. So what's being done to tackle these issues? Well, in the UK, we have Roma and traveller NGOs who are very well organised and work tirelessly to persuade those in central and local government to take meaningful steps to tackle the prejudice and inequalities faced by these communities, and to explain to politicians that if the accommodation problems were addressed, then that would inevitably lead to improvements in education, health and employment. But those in power don't seem to be interested. Leadership from the UK government on tackling inequalities and prejudice experienced by Roma and traveller communities has been woeful, with the situation being made far worse by inflammatory and racist language being used by politicians, particularly at the time of elections, when they pander to the prejudices of the majority. And this depressing situation is obviously not confined to the UK. There seems to be little political will across Europe to tackle the discrimination and inequalities faced by Roma and travellers. So then how can we as lawyers help tackle that prejudice, that racism, and the inequalities experienced by Roma and travellers? Well, I believe that lawyers, we can make a very real difference. First, by taking cases for Roma and travellers which challenge laws and policies adopted by central and local government which discriminate against them, and also by offering to represent Roma and travellers when they wish to challenge the discrimination they face in day-to-day life, for example, when accessing goods and services, whether in the public or private sector. But the other way I think that we can make a difference is by ensuring that they have the knowledge to understand their rights and advocate for their rights, and that lawyers generally have a better understanding of the issues so that they may then be motivated to get involved. So it's my, I suppose, experience that in the UK we've been able to publish information about cases and arguments that can be read and used by other lawyers who are interested in working with Roma and travellers to protect their rights. That information can also be circulated amongst Roma and travellers and the NGOs which support them so that they can understand and use the law themselves and use their knowledge to lobby politicians for meaningful and positive change. Just looking at the first point, litigation, Roma rights litigation in the UK, and I've told you about the factual situation in the UK, but that sets the scene for many legal battles that I and other lawyers have fought in recent years in both the UK domestic courts and in the European Court of Human Rights, in an attempt to persuade the state to recognise and facilitate the traditional way of life of Roma and travellers. So I'm going to give you just a few of the highlights. In 2001, in the case of, forgive me, Chapman against the United Kingdom, the European Court of Human Rights held that the eviction of a traveller from her caravan site would also have an impact upon the right to respect for her private and family life, and that right includes a right to respect for her traditional way of life, an integral part of which involved living in caravans. Thus, the court said that the applicant's occupation of her caravan is an integral part of her ethnic identity as a gypsy, reflecting the long tradition of that minority of following a travelling lifestyle. And it said that this is the case even though under the pressure of development and diverse policies or from their own volition, many gypsies no longer live a wholly nomadic existence and increasingly settle for long periods in one place in order to facilitate, for example, the education of their children. And the court concluded that measures which affected the applicant's stationing of her caravans had therefore a wider impact than on the right to respect for home. They also affected her ability to maintain her identity as a gypsy and to lead her private and family life in accordance with that tradition. Now, importantly, the court in that case and in others recognised that the vulnerable position of Roma and travellers as a minority meant that there was a requirement on the state to give some special consideration to their needs and their different lifestyle, both in the relevant regulatory framework and in arriving at the decisions in particular cases. And to that extent, the court said there was thus a positive obligation imposed on the state by virtue of Article 8 of the Convention to facilitate the Roma or Gypsy way of life. Then back in the UK, in a domestic court that I was also involved in, called Clark, in 2002, a planning inspector, a zoning or planning inspector, appointed by the Secretary of State, refused a Romani Gypsy planning permission for his caravan site. The inspector did so, having rejected the Romani Gypsy's argument that he could not live in bricks and mortar. He needed to live in accordance with his cultural tradition in his caravan. He had been offered bricks and mortar and taken his wife to see the house. And his wife refused to go across the threshold. She couldn't bear it. And so he rejected that offer. And when it came to his appeal before the inspector seeking planning permission for his caravan site, the inspector said, well, you did have a choice. You could have taken up the bricks and mortar and rejected the argument that that would be contrary to his traditional way of life. He then challenged that decision, and I represented him in the High Court, and the judge, a very enlightened judge, I should say, quashed the inspector's decision and said that in appropriate circumstances it can amount to a breach of Articles 8 and 14 of the Convention to weigh in the balance and hold against a gypsy applying for planning permission or indeed resisting eviction from council or private land that he or she has refused conventional housing accommodation as being contrary to his or her culture. So we now have in the UK established case law explaining that gypsies and travellers who have a traditional way of life, an integral part of which is living in caravans, are entitled to respect for that way of life. That doesn't mean they will always get planning permission, but it's an argument, and a very strong argument, that they can now deploy in such cases. Then in 2005, the European Court of Human Rights gave judgment in another traveller case, the Connors case, and held that Mr. Connors, who had been evicted from a local authority site, had his rights under Article 8 breached because he wasn't able to challenge the eviction in a court of law, in an independent court of law. And that decision eventually led our government to amend the existing legislation to give Romani gypsies and Irish travellers living in caravans on local authority-run sites security of tenure. And so it was a great victory. But despite cases like Chapman and Connors and others like Yordanova against Bulgaria, for that anyone who knows it, and the Winterstein case on forcible evictions, the reality is that those evictions continue and the legal arguments just get more complicated. In the UK, the police and local authorities have various statutory powers which they can use to evict travellers from unauthorised encampments, but which the courts have held, in accordance with the European Convention on Human Rights, must be used proportionately and on a case-by-case basis. But a number of local authorities have recently tried to circumvent that requirement by asking the courts for borough-wide bans encapsulating or covering huge areas of land, prohibiting unlawful encampments anywhere within those large areas. I represented an NGO in one of these cases against a local authority, and the case went to the Court of Appeal. And in the Court of Appeal, the judges noted that by that time, 38 local authorities had applied for these wide injunctions. And the judge who gave judgment said it would be unrealistic to think that their widespread use has not led to something of a feeding frenzy in this contentious area of local authority responsibility. First, these injunctions have had the effect of forcing the traveller community out of those boroughs which have obtained injunctions, thereby imposing a greater strain on the resources of those boroughs and councils which have not yet applied for such an order. And secondly, they've created an understandable concern amongst those local authorities who have not yet obtained such orders to seek them forthwith. So it's like a knock-on effect. And this feeding frenzy was halted by the Court of Appeal in that case, because the Court of Appeal gave rigorous guidance on when those injunctions might be granted. And in doing so, held that there was an inescapable tension between Article 8 of the European Convention and the rights of the traveller community and the common law of trespass. And it said this: the obvious solution was the provision of more designated transit sites. They said it was a striking feature of many of the documents before the court that the absence of sufficient transit sites has repeatedly prevented any coherent attempt to deal with this issue. The reality is, the court went on, was that without such sites, unauthorised encampments would continue, and attempts to prevent them may very well put the local authorities concerned in breach of the convention. And they added that these borough-wide injunctions were inherently problematic because they give the gypsy and traveller community no room for manoeuvre. And finally, and this was perhaps the best paragraph of the judgment, they said this: it must be recognised that the gypsy and traveller community have an enshrined freedom to move from one place to another. An injunction which prevents them from stopping at all in a defined part of the UK comprises a potential breach of both the Convention and the Equality Act legislation, and in future should only be sought when a local authority concludes that there is absolutely no other way in which to address the problem. Now, though that decision represented a significant victory, it may be of little effect because our government, and you may have heard something about the nature of our government from the TV in the last few days, maybe the last few weeks, but our government brought in legislation earlier this year which has given the police even greater powers to evict travellers from unauthorised encampments. You may not be surprised to learn that I've been instructed to challenge that new legislation, but we're fighting a legal aid battle at the moment to see whether or not we get the opportunity to do that. Now, these cases I've highlighted all relate to the cultural accommodation needs of Roma and travellers, but we know that many other cases are brought by Roma and travellers in our domestic courts and in the Strasbourg court on matters such as death in custody, the failure of the state to investigate such incidents, discrimination and segregation in education, forced sterilisation, awful examples. So I would urge, and I've only got a very limited amount of time to speak now, those amongst you who are moved and motivated by what I've been telling you about the difficulties and inequalities that Roma and travellers face, to get involved and for those communities. I would add that knowledge is power, and raising awareness of the issues and also the law that can be used to tackle those issues is essential. So with my colleagues, I've written a book called Gypsy and Traveller Law. It's about this thick now. It's too thick to bring on the plane. Yeah, it would take up my luggage, too much of my luggage. There is a book which has been published by the European Court of Human Rights, which I edited, Ensuring Access to Rights for Roma and Travellers. It's a bit out of date now, but there are these sources and others that you can access, including the European Roma Rights Centre website, if you're interested in learning more. And once you get involved in this work, I think you'll find, and this is my own practical experience, having worked with Roma and travellers for 35 years, that it will be the most rewarding and satisfying work that you will do throughout your career. And it's on that basis that I would urge you to get involved if you haven't already been convinced by what I've said. Finally, in conclusion then, perhaps I should remind you of the words of the Nobel Peace Prize winner, Václav Havel, who said that the litmus test of the democratic society is how we treat the Roma. Those words should never be forgotten. And as lawyers, we need to ask ourselves, really, why do we do this job? If, as I think it is, we do this job because we want to make a difference, then working to tackle the pervasive prejudice and racism faced by Roma and travellers seems to me to be an ideal way of doing so. And I hope you all agree and take up the challenge. Thank you.
We thank Mark Willers very much. We thank Mark Willers very much, and I wish we had more time. I took notes and I benefited very much. Thank you. Now our last speaker comes. Yulinda Bekiray. She is from the Bingham Center for the Rule of Law, the British Institute of International and Comparative Law, BIICL. At the Bingham Center, she leads and develops the research and events programs in European law, including trade and human rights issues, and publishes high-quality research for the Institute in these areas. She also contributes to the Bingham Center's work on access to justice and has worked extensively on rule of law and access to justice issues for vulnerable groups, including in the context of Sustainable Development Goals. She holds a master's degree in international affairs from the Institute for International Political Studies in Milan and a PhD from the School of International Studies, Trento, Italy. Prior to joining the Bingham Center in 2014, she worked for several years as research fellow and lecturer in international law at the University of Trento, lecturing courses on WTO law, international and EU law. Dr. Becky Raj's research interests cover international economic law, international migration and human rights protection, and including with an EU focus, the rule of law and development. Now we turn the floor over to her.
Thank you very much, Neva, for the lengthy presentation. I hope you'd read only the first paragraph, but thanks for going over that. So first of all, thank you very much to the organizers for putting together such a fantastic conference and for the opportunity to contribute to the debate on such a topical issue. I have also prepared some speaking notes, which I will read in order to smoothen as much as possible the interpretation. But let me first say something, or at least explain the main idea or behind my presentation. Until now, we've addressed access to justice as a human right, and rightly so. But I wanted to bring another element or another element of support of why it is important. And it's the link that is made in the context of the Sustainable Development Agenda, the link between access to justice on the one hand and poverty reduction and development on the other. So I will dedicate the first part of my presentation to explaining this link, why they are mutually beneficial and why it is important, or at least it is another argument for states to protect and promote access to justice if they think about it also from the perspective of development and poverty reduction. And then in the second part, I will talk about some aspects of access to justice for children that are relevant in this respect of the link, once again, the relationship between the two elements. So let me start by saying that access to justice is a precondition for and an enabler of the full enjoyment of all other rights and fundamental freedoms. Now, over 365 million children live in extreme poverty, and this is half of the population of Europe or the entire population of North America. Child poverty is not just about the lack of economic resources, but it's about lack of opportunities. It's about access to opportunities that would trigger their development and lack of security and protection from risks and vulnerability. Access to justice is at the core of guaranteeing children's rights, but legal systems often make it difficult or impossible for children to obtain redress for rights violations. Access to justice is especially important for protection from discrimination, violence, abuse and exploitation, and for ensuring the best interest in all activities involving and having an impact on them. Sorry. Apologies. So, the main issue that was mentioned by previous speakers is that because of their dependent status, children are most vulnerable when they need the justice system or come into contact with it, either as victims or as witnesses or as offenders, or when judicial or administrative intervention is required in relation to their custody or protection. So, from the rights perspective, the framework for rights is established in international law. It was already mentioned by previous speakers, and rests, on my opinion, on two key instruments. Although one is purely a human rights instrument, and the other one is what I mentioned earlier, the Sustainable Development Agenda. So, access to justice is defined in the UN system. The access to justice for children is a right in itself, and for the enjoyment of and is essential for the enjoyment of other rights. And this is clearly established in the UN Convention on the Rights of the Child, UNCRC. And this is the reference document containing binding commitments that are applicable globally. Almost the totality of the UN member states, with the exception of the United States, I understand, have ratified the convention. So the UN system in general embraces an expanded notion of access to justice. This was also partially touched upon by previous speakers. What does it mean, access to justice? Is it just access to a court, or does it go beyond that? So it is much more than improving an individual's access to courts. It must be defined in terms of ensuring that legal and judicial outcomes are just and equitable. As the Committee on the Rights of the Child which monitors the implementation of the Convention, as it explains, and I'm quoting them here, children's special and dependent status creates real difficulties for them in pursuing remedies for breaches of their rights. So states need to give particular attention to ensuring that there are effective, child-sensitive procedures available to children and their representatives. So these include provision of child-friendly information. Information is an important aspect. You also mentioned it earlier. Advice, advocacy, including support for self-advocacy and access to independent complaints procedures and to courts with necessary legal and other type of assistance. Where rights are found to have been breached, there should be appropriate reparation, including compensation, and where needed, measures to promote physical and psychological recovery, rehabilitation, and reintegration. As noted in the report of the working group of the Universal Periodic Review, this is a mechanism based at the UN, Turkey has taken significant steps in the past years, notably with the ratification in 2017 of the optional protocol to the Convention on the Rights of the Child on communications procedure. So the protocol was signed in 2012 and was ratified in 2017. Thanks to this ratification, children have the right to appeal to an international mechanism specific to them when national mechanisms fail to address their violations effectively. I guess one of the speakers from the first panel also mentioned this. But while this is the human rights protection, so the first approach and the approach that has been under which the problem has been addressed until now, a second perspective is that regarding the international commitments to sustainable development in 2015, which have set out a way forward that will be profoundly important in the protection of children's rights. Access to justice for all is a key priority in the agenda for development, and it is one of the 17 sustainable development goals that were unanimously adopted in September 2015 by the UN General Assembly. These are part of this, I already mentioned, Sustainable Development Agenda that will direct international development, international aid and development until 2013 and hopefully the commitment will be renewed. So the agenda recognizes the relationship between poverty reduction and sustainable development on the one hand, and respect for fundamental human rights, the rule of law, justice and equality on the other. It rests on the understanding that justice systems can be powerful tools in breaking the cycle of poverty by empowering vulnerable groups and individuals. So while this is the role, while this explains the role of justice in relation to development, the agenda also acknowledges that children and young women and men are critical agents of change and predicts that the new goals will provide a platform to channel their infinite capacities. So effective access to justice for all is incorporated for the first time as a standalone goal in this Agenda for Sustainable Development. And the text that accompanies this goal is SDG 16, so Sustainable Development Goal 16, sets out to promote peaceful and inclusive societies for sustainable development, provide access to justice for all, and build effective, accountable, and inclusive institutions at all levels. So the inclusion of this specific goal, addressing institutional aspects and access to justice, within this sustainable development framework is hugely significant because by unanimously adopting the agenda, governments have agreed to prioritize its elements in both domestic and foreign policies. So the agenda also comprises other commitments aimed at offsetting detrimental effects of poverty on children and empowering them in the context of sustainable development. Now, one aspect needs to be underlined, and it is that the agenda as such is not binding, differently from the Convention on the Rights of the Child. It's not a binding instrument, it's voluntary, it's aspirational. However, it is accompanied by an indicator framework showing the progress that states have made or will make in this time frame, 2015-2030. And therefore, it introduces a concrete mechanism based on political and civic peer pressure for holding governments to account, and thus gives some teeth to the agenda. So, as regards children specifically, and I now go to the second part of my presentation, there are more than 20 indicators agreed to measure progress in relation to the achievement of SDG 16. And 7 of these are of particular and direct relevance to the realization of children's needs and rights. There is an indicator talking about violent discipline on children, victims of human trafficking, victims of sexual violence, crime reporting rate, unsentenced detainees, unregistered children at birth, experience of discriminatory behavior, etc. I will address here just 4 of them. And this part of the presentation relies on 2 reports that, together with a colleague, Lawrence McNamara, we developed at the Bingham Center, based on feedback that we have obtained from the bar associations from different countries across the world. So let me first also, I understand that this slide hasn't been, so it's not translated in Turkish, so maybe this one might be easier for you to understand how much progress has been made in relation to the different indicators related to Goal 16. Goal 16 is just one of the labels. No, I meant one of the 16 icons there. But all the arrows and, I'm sorry, I don't think the slide shows fully, but you can anyway understand the colors and whether progress has been made, but there is much more need to put efforts on that, or whether that target has been realized or not. So, with regard to violent discipline, it covers punishment of children by those who take care of them, and it aims to cover practices of violent discipline on children in the form of physical punishment, including mild forms of physical discipline and psychological aggression. This is typically happening in schools, in institutions, at homes, or at work. So while this kind of violence is not always justiciable because it may be culturally acceptable in certain contexts, the indicator aims at raising awareness on practices of violent discipline involving children with longer-term purpose of triggering interventions that are necessary to strengthen the respect for children's rights. So one phenomenon discussed in the report and was also mentioned in the previous panel concerns the situation where violent discipline may occur when children are forced to live in prisons with their parents who are living in prison. So the children as such are not convicted, they are just forced to live with their parents who happen to be in prison. So deprivation of liberty for children, including in the context of pretrial detention, should be a measure of last resort. The SDGs are of crucial importance in this respect because obtaining data on violent discipline and on pretrial detention, including should disaggregated, especially by sex, age, and length of detention, will enable understanding the scope of the phenomenon and will help in detecting gender equality issues, for instance, where the level of unsentenced detention exists. So what is the level of unsentenced detention that exists for boys and girls, and whether this is different? So, children detained with parents are an invisible and often a highly vulnerable group. Human rights bodies recommend that decisions allowing a child to live in prison with the mother should be subject to judicial review. They also recommend that the living conditions should be as close as possible to those of a children that is not in custody. And such practice apparently affects, in particular, migrant children and their families in Turkey. This emerges from the report of the Committee on the Rights of Migrant Workers. Therefore, the committee has recommended that there is an expeditious and complete cessation of detention of children on the basis of their parents' migration status and the adoption of alternatives to detention that allow children to remain in non-custodial contexts. Another indicator of Goal 16 is crime reporting rate. Once again, crime reporting rate is about all types of crimes, but since the data needs to be disaggregated by age, it is possible also to understand which crimes and how, what share of the crimes affect children. In addition to the ratification, so in addition to what I mentioned earlier, the ratification by Turkey of the optional protocol of the Convention on the Rights of the Child, under the National Program for Combating Child Labor, which was launched in 2017, children may submit appeals through a separate web page on the website of the Ombudsman Office. However, in some occasions, especially with regards to migrant victims of crime in detention facilities, it has been flagged up that civil society organizations have limited access to facilities, which reduces the chances of reporting the crimes committed. So it has been recommended that civil society organizations with respect to Turkey should be guaranteed unhindered access to detention facilities to enable them to support detained migrants and their family members more effectively, including children. Also with regard to the police investigation phase in matters where children are victims of violence, it has been recommended that Turkey should develop education and training programs, and that such programs on the operationalization of the principle of the best interest of the child should be made available to all officials and other groups operating with minors. Let me come to another point, which is about birth registration. Birth registrations are also considered in one of the indicators of this goal, and they are essential to accessing a range of civil, political, economic, and social rights. So, UN human rights monitoring bodies have praised Turkey, reporting that statelessness is not an issue when it is and is not an issue, and that Turkey is committed to universal birth registration. So all fine on this. However, concerns have been raised over the lack of a comprehensive strategic approach to planning and registering the births of migrant children in Turkey. Accordingly, Turkey has been recommended to ensure that all migrant children are registered at birth and issued with personal identity documents, and that there is awareness raising. There are awareness raising campaigns on the importance of birth registrations among migrants, especially those in an irregular situation. My last point, and which is another illustration of an indicator under Goal 16 that is relevant for the rights of children, is the indicator regarding victims of trafficking. The number of victims of human trafficking is there is a lack of data on the scale of trafficking in Turkey, and in particular when the numbers are disaggregated by women and so the rate of women and children. And the recommendation is, on the one hand, to evaluate the scale of trafficking in persons and compile systematic disaggregated data to better combat this phenomenon. And on the other hand, Turkey is recommended to strengthen training for law enforcement officials, judges, prosecutors, labor inspectors, teachers, healthcare personnel, and disseminate more widely information on trafficking in persons and with regard to victims' assistance. So you cannot improve what you cannot measure, and this is why, and this is my concluding point, this is why the Sustainable Development Agenda is a very good complement to the existing human rights protection framework. Thank you.
Bir 10 dakika kısa bir ara vereceğiz ama aradan önce bizim derneğimizin, Eşit Haklar İçin İzleme Derneği'nin de başvuru.
We will have a 10 minutes of a coffee break, but before that, we will provide some information.
Çok teşekkür ediyorum.
Thank you very much. Mehmet Onur Yılmaz, thank you for allocating 2 minutes of time before the break. And I would like to thank the organizers for giving me this opportunity. As Merve said, Abdullahi was one of the applicants for the Association for Monitoring Equal Rights. I would like to briefly inform you about the topic, and I would like to make a call for support. That's why I am here, and thank you for giving me the permission. Muhammed Abdullahi came to Turkey because of an educational agreement between two countries. He is from Somali and he completed his university education. Because of risks of returning back and returning to his home country, he decided to live in Turkey. And he took over a restaurant and started to manage it with his brother. And these are people living in Turkey. They have residence permits and they are taxpayers. And you might remember the news on Sözcü newspaper, like Africans invading Turkey. After this news article, several law enforcement took it as an opportunity and started to raid the restaurants owned by people from Somali. They tried to go to these restaurants midday. 8 to 10 police officers, imagine them arriving at the spot and then making identity checks. And sometimes they take all these people to police stations and repeat such activities every week. And Muhammed Abdullahi does what can be done by a regular citizen and complaining about the things that the police does. And he files a complaint. And about a week or 10 days later, the police officer comes with the document telling them he received the complaint. However, the practice continues, and then he applies to the Turkish Board of Equality, and he is actually following the regular steps, and this application was completed last week, and maybe the worst decision in the history of the Equality Agency was given, and the president and the 5 other members objected and said that there was no discrimination in the process. But he heard that we don't want black people in Kızılay by police officers, and he heard that your color attracts a lot of attention. He heard all these comments. However, the board decided that there was no discrimination. As he did not agree with this decision, he announced what has happened on social media. And after this announcement, his residence permit was cancelled. Afterwards, a decision for extradition was given. And on the 20th of September, with the signature of the officer he filed a complaint against, he is being held at the extradition center. And his cases are still being seen at the court. And concerning access to justice, there are many foreigners who have similar situations like the ones he has experienced. He is more persistent, maybe in that regard he is lucky. On the other hand, things might have happened because of this attitude. He is still kept there, but there are people who might stay in that center up till 6 months. If he goes back to Somali, there is a possibility that he can get killed. And despite this is the case, the officers at the center try to make him sign a volunteer form for extradition. And Muhammad told his lawyer that he wished he didn't know Turkish because he listens to all the talks around him. That is the current situation. If you have a photo taken outside and publish it on social media with the hashtag Muhammad, then it will be helpful. We, people living in Ankara, cannot digest what has happened to him. As people who have convened here today, we can support him. And the restaurant to which Mohammed is a shareholder is still open. They continue to serve nice African food, and it is at the corner of Sümer Street and GMK Boulevard. Of course, there is no sign that was damaged by the police officers. The reasons being they didn't like the name. When they hang the second sign, they didn't like the colors this time, and they weren't convinced that these were the colors of his continent. The restaurant is still open without any sign in front of it. We want to free Mohammed. Our fight will continue. Thank you very much for listening. So I would like you to be here in 10 minutes. We will start the last session at 4:45. You can ask the questions to our speakers during the break. We do not have, unfortunately, time for questions at the moment. I can say it immediately. It is short. Actually, all the sessions since morning helped us to see the difference between the civil society and academia. In the morning session, for example, we listened to presentations and children's rights were covered, and in Turkey it has been quite recent that we are focusing on laws about children's rights, and I wished we could hear about the impunity policy while we discussed women's access to justice. And there was a list about changing the location of the courthouses. However, this does not reflect the reality of the situation. It shows us that academia is quite far away from the realities of the day. And I believe if this gap is bridged, that will help navigate the problems better. And the importance of Istanbul Convention needed to be mentioned in the presentation about women's access to justice. Thank you.
Kaçta geleceğiz onu söyle. 16. 50 geçe son oturuma başlayacağız.
We will start the last session at 10 to 5. We already have a delay. Please be here on time. Thank you.
Kaderidir. O yüzden. Şuraları da bir toplasalar. Ha. Şunu da alırsın. Ben son 2 dakika kala uyarı yaparım konuşmacı arkadaşlar için. Siz de toparlarsınız. 20 dakika. Çok hızlı. Evet, tercüme de edildiği için çok ya ana başlıklarla temel sorunlara değindiğinizde bu
ülkelerdeki sorunda yaşadım. Ben biraz hızlı konuştuğum için gene son konuşmacıysa hani böyle artık hani herkes bayılıyor.
turşuya dönmüş herkes.
Yola koştum. Tercüme sürekli duyuyorum. Şöyle yavaşlasın. Bir yerde bırakmışız.
Lanet olsun diyerek. Aman. Yavaş olalım evet.
Geçelim oturalım bence.
Ha, buyurun geçin. Bizim sesimiz de duyuluyor değil mi?
Ya. Ortak siz mi yapacaksınız?
Siz böyle gelin. Bir kişi oraya, bir kişi de oraya oturdu mu? Biz başlayalım. Herkes dışarıda.
Moderatör sizsiniz
Evet, benim.
değil mi? Bir ricam olacak.
Tabii
Biraz
ki.
toparlayabilir misiniz? Şoförmenler saat 6'da ayrılacaklar.
Tamam. Ben konuştum.
Biraz kısıtlayarak.
Tamam.
Çok özür dileyerek
Yok hayır.
Çok sert mi oldu biliyorsunuz ama
Hayır ben de öyle söyledim zaten bir an önce yani bitirelim. Çok uzatmayalım. Süreye riayet edelim. 50 geçe 55 geçe başlarsak bir saatte bitiririz. Zaten 3 sunum.
6'da ayrılacak
Tamam. Hallederiz. Hiç merak etmeyin.
Hocam bir sandalye daha çekelim mi? Yoksa nasıl yapalım? Nasıl uygun görürsünüz?
İsterseniz siz önde oturun. Bir soru olursa
Tamam,
siz
ona
de
göre yapalım.
şey yaparsınız.
Tamam.
Evet sunum yapacak.
Bence hiç şey yapmayalım.
Kimse? Çin yapmayacak mısınız dışarıda?
Zaten çok şey oldu. Aşırı geciktik. İnsanları tutamıyorum. Yani.
Tamam. Çekiliş yapacağız sonunda falan da bir şey.
95. Direkt slide sayfası açılacak.
Evet. Evet. Çevirmenler bir şey olsun. Evet, son oturuma başlıyoruz.
Yes, we are start the last session, and it is unlucky that this is the last session because the attendance gets significantly decreased, and as the case in the morning and the afternoon session, we have presentations related to the subject matter. We have 3 presentations. The first presentation is about the international authority of Turkish courts in cases concerning children who are away from their families. Avukat Ali Kahraman graduated from Anadolu University School of Law. He is registered in Mardin Bar. Roselin Telleoğlu graduated from Çukurova University School of Law, and she works as a lawyer in Adana. Yes, you have 20 minutes. The floor is yours. First of all, I would like to thank Association for Monitoring of Equal Rights for organizing this event, and also Atılım University. Our topic is the international authority of the Turkish courts while dealing with children who are away from their families. And we will talk about the custody and trusteeship of separated asylum seekers. And the number of people who took refuge in Turkey is increasing during recent years because of the turmoil in countries like Syria and Afghanistan. And there is an increase in the number of personal law cases these people are Turkey to. When a mass or individual asylum movement takes place, minors are often left unaccompanied, or they are separated from their parents. In cases where children cannot come with their guardians but take refuge in Turkey with another relative, or if they are separated from their parents after taking refuge in Turkey, they must be placed under guardianship in order to access their basic rights. Since the cases regarding the guardianship or trusteeship of minors who took refuge in the country contain an element of foreignness, these cases should be handled by considering the conflict of those rules. So the types of asylum in Turkish law and the international jurisdiction of Turkish courts will be handled. The first regulation in our law was the Geneva Convention. Turkey signed the Geneva Convention in 1961, and when signing the convention, it placed a geographical restriction on the definition of refugee and stated that the refugee status would only be granted to people who sought protection due to events taking place in Europe. This convention was followed by the regulation on procedures and principles applicable to foreigners who have taken asylum in Turkey, and the geographical limitation continued in this regulation as well. In 2013, foreigners and international protection law came into force. Definitions of refugee, conditional refugee, subsidiary protection, and temporary protection were regulated. According to the Foreigners and International Protection Law, refugee is defined as the status given to foreigners who took refuge in our country due to events occurring in Europe, conditional refugee due to events occurring in countries outside of Europe, and secondary protection due to events that cannot be included in these two statuses. And as for the temporary protection, it is given to people on fleeing persecution. Both persons with both international protection and temporary protection can benefit from basic services like health, education, and social assistance, in addition to having a legal right to stay in Turkey. We talked about the international protection and temporary protection legislation. I am trying to skip some parts of my presentation. I will talk about the guardianship and trusteeship. And so here we won't be making an evaluation for adults, but we will limit our elaborations on minors. And this is regulated in the civil law, and the minor who is the subject matter, all the rights need to be protected, and an individual is assigned as the competent guardian. And while carrying out their obligations, administrative authorities and the courts need to inform the agencies about the situation. Trustee is the person who is appointed by the court, and he performs only limited responsibilities, and guardianship is of a more general nature, whereas trusteeship is limited. And there is a minor difference that needs to be mentioned here. As I skipped, I was very fast, and now the floor is to Roserin. Thank you very much, first of all. I'm not sure if you can hear me. In fact, as Ali mentioned, we are talking about the custody and trusteeship for children who seek asylum in Turkey. It is not about others. So this will be the scope of our analysis. We have two sources. One is the Hague Convention of 1996, which is being implemented in Turkey since 2007. And we also have the law on foreigners. And we are analyzing these in terms of authority to begin with, and we try to see which country's law will prevail. First, we will deal with the Hague Convention, and we start with Article 7. And refugee children, or if they had to leave their country, and if these are under custody or trusteeship, and if they are in a country who is a party to the convention, then the authorities of that country have the authorities defined under Article 5, it stipulates. And concerning the protection of these children, the courts are authorized, it says. And Turkish courts in that regard are authorized. And it doesn't risk itself. And in all the emergency conditions requiring the protection of the children, under Provision 11, we see the same being in place. And in MEHUK, we see that if the individual's residence is outside of Turkey, then there are special authorities given to the court. And as we are dealing with the cases of the asylum seekers, then the place of residence of the person needs to be considered. Do asylum seekers have a settlement in Turkey is another question. If we accept that they do have a settlement, then Turkish courts will have the authority and based on the other opinion, they are under guardianship, they have ID numbers, however, they do not have a place of residence in Turkey. And if we have this opinion, we have to use Article 42. And if there is a case concerning the custody or trusteeship, then the court of the place where the minor is a resident should have the authority. We first have to respect the convention and the law, but in both instances, Turkish courts have the authority. So, which country's law should we be implementing? 1996 Hague Convention stipulates that if I give all the authorities to the said country, then the law of that country will be implemented. But we then have to see MEHUK as well. And in Article 10, it says that first the domestic law should be implemented, and then other conditions should be evaluated. If this is a minor, then first for refugees, the state of residence is considered, or the country where they reside in at the time of the and at the time this was covered, the temporary protection status was not available in the Turkish law, and should we cover them under 4A? In order to decide about this, we had to check the explanation. And for articles where the domestic law presides, we have to show which law should be used, and that is why 4A is used. And those who are under temporary protection should be also covered under 4A. So the courts at the place they reside in should handle these cases with domestic law. Yet, how is the situation in Turkey? I will show you a couple of judgments. First instance courts and regional courts judgments will be covered. And so they check if there is an element of foreignness, and why they don't discuss why they are handling these cases. I haven't seen such a judgment. I have seen a couple of examples in divorce cases. However, why am I authorized or why am I implementing domestic law? These are not discussed. This is a decision from Adana court. There is a Syrian grandmother and a guardian will be appointed. The dad has died in Syria, and the mom could not be found. And as the child could not be enrolled in school, then she has to be appointed. And of course, it is not only about not discussing the foreignness. And there are children who have come to Turkey with their aunts and uncles. However, these people who are custodians do not have the authority in access to healthcare and access to education. These are basic rights available to children, and they should be able to have access to these. And at one point, a child received money transfer for the education, and we had applied for trusteeship, but the brother then has to prove that he is the brother. And these people are coming from areas of conflict, and they usually do not have any documents showing the family relationships. Then you have to file for other cases at the court. And there is an individual who wants to be the trustee for the grandchild. And in order for this appointment to take place, we have to first file a case eliminating the guardianship of the parents. And first we file the case for this purpose. However, as we cannot reach the parents, these are denied. These were negative examples, and however, I have good examples as well in both of these judgments. In one of them, there was the grandmother, and in the other, grandfather, who were authorized, and they only have trusteeship for certain tasks, like enrolling the grandchildren to school. And when it's published, you will see that there are many other areas of responsibility as well. I will give the last word to Ali. So I guess I have to cover bad judgments. So once the decision, if there is a case for eliminating the guardianship, these are very difficult, and there are related problems. And these cases take quite long to deal with. And it is not only about filing the case, but the family has to be informed about the judgment as well. So this was a case at a Midyat court. The children were living with their grandmother, and the grandmother wants to be the trustee. However, the court, as these children are coming from Syria, and their ID cards given by the Syrian authorities are required, but the grandmother cannot go to Syria to receive the documents. And when they came from Syria, the children were small probably, and they did not even have ID cards. And it wasn't possible to have access to these documents, and we do not know what type of a judgment the court will give under these circumstances. And this is a case from Adana, from a family court. And as this document was not provided to the family, it will be very difficult to arrive a judgment, and so probably the decision of trusteeship will not be given. I guess this concludes our presentation. We try to be as quick as possible. Thank you very much.
Evet, demek ki sert bir moderatör olunca süreye uyuluyormuş.
Tough moderator, obviously, people will keep to their time. The topic that the colleagues talked about is very important. I really observed this in registrations for school, and this really locks the way forward of immigrant children. Now, the second paper is the role of forensic social work in access to justice for disadvantaged groups, prepared by Dr. Mehmet Öcal and Özge Kutlu Dönmez. Dr. Mehmet Öcal is a graduate of Süleyman University. He finished his MA and PhD there as well, and he is teaching now. Özge Hanım is a graduate of social services in 2017. She is now pursuing her graduate studies. And you are still working as a social service expert, social worker. Is that right? Yes, she says. I hope there are no problems with respect to the sound system. Welcome, dear participants. We are all very tired. I would like to ask you for your patience. In our paper, we wish to take the question up from the viewpoint of social service. So the title is The Role of Forensic Social Work in Access to Justice for Disadvantaged Groups. Now, we are going to take up this question from the human rights perspective, and I will look into physical, objective, and subjective barriers in the enjoyment of these rights. And then there is a bridge, something that serves as a bridge. What kind of practices can be carried out as a bridge by the social services profession? We have been talking about access to justice since the morning. We have said that this is a very fundamental concept with respect to human rights, and it is very important from the point of view of the materialization of social justice. And this is a precondition for the enjoyment of other rights. Why is access to justice important for disadvantaged groups? Because if they wish to struggle against discrimination, they need an instrument, and this is it. Perhaps when we first say access to justice, we can perhaps imagine something physical, very narrow, and someone going to court and being able to access to the courthouse. But this concept has very different aspects. What are these? In the legal system, the individual needs to enjoy all the rights completely, and these rights and freedoms should be executed in a fair and equitable manner. This is much broader. When there is a restriction on the access to justice, then there will be, of course, loss of confidence to the justice system. Individuals who seek justice will have to access justice in an uncostly manner. Well, in the context of access to justice, disadvantaged groups. What is disadvantaged? These are situations where the individual cannot be self-sufficient. Certain sectors of society, for different reasons, cannot enjoy social resources, cannot enjoy the use of social resources as much as others. This may be outside the intervention, the willing intervention of the individual. It may be a result of the dynamics of the society in which the individual lives. Migration, war, and other causes may be behind this. So, when we take this in the context of access to justice, disadvantaged people have a serious disadvantage with respect to access to justice. There are three groups that we want to take up. One, the access to buildings for disabled people with disabilities. In particular, the access to metropolitan justice palaces. And this really rises in front of us like as a physical barrier. This lack of accessibility to these buildings is very important. With respect to women, this was touched upon earlier. The judicial system works only during work hours, but if you're working, you cannot really enjoy services of the system during those hours. And then there is, of course, the question of other disabled people, such as migrants and others, who cannot have access to these buildings. When we come to objective barriers, well, the question of the high costs of the judicial process, and this is a serious obstacle in the access to justice. There, of course, delays in the decision process of courts. There may be very many reasons for this, the number of cases, files, and the number of cases per judge, etc., etc. And so temporal delays are also a barrier in the access to justice. Together with this, the different complexities of the judicial system, we talked about this in terms of complexity, is really an objective barrier. Then there are subjective barriers which derive from the individuals themselves. When they have very little information with respect to their rights, etc. These are subjective barriers, because if you cannot start a process of access to justice if you're not aware of your rights. What are forensic social services? This is in the sphere of field of intersection of law and social services. This aims for social justice and social peace. As we all know, this access cannot be provided for only with positive measures. Then there need to be additional interventions to teach people how to use different judicial systems, to teach people how they are different, and there may be consultation offices, and for all of these new solutions may be proposed. And one part here falls to the experts of social services in the forensic social services. What kind of work do we carry out? from the beginning to the end of the judicial process, we provide consultation services. We do advocacy work. We do work on individuals so that seeking justice really reaches its ends. And we also provide access for the health of the people who seek justice, and we also provide different therapies, psychologically speaking. And then we also prepare materials which are informational on the process. These are the micro ones. The meso ones are directed towards the system itself to a certain extent, because research shows that the workers of the legal system also have negative impact on the access to justice of these people. So we work with the personnel. This is part of the meso practice. When we come to the macro level practices, this time at the level of society, social education and training activities, applicants, society and other demands are taken into consideration, and certain applications are developed. And what are the barriers in the way of the realization of access to social justice? There may be research done on this area. Very briefly, I wanted to share with you very briefly, I said, as we have certain proposals in order to make it possible for disadvantaged groups to have access to justice. Social service experts can do work in order to increase the level of awareness of people with respect to justice system. The judicial institutions have lots of barriers in front of the way of these disadvantaged groups. To eliminate these is an important objective. And then good practices, best practices, may be used for this purpose. I would like to finish up with a quotation from Mustafa Kemal Atatürk. In the legal system, the really important thing is to distribute justice without tiring, without exhausting the citizen. Thank you very much.
Teşekkürler Özge Hanım.
Thank you very much, Özge. Thanks for respecting the time as well. Because after you, there is Mert, and academicians usually take long while elaborating, so there is time to cover that as well. Our last speaker will be Dr. Mert Duygu. His topic is legal fees and legal aid in the context of access to justice. He is a graduate of Istanbul Ticaret University, and he finished his PhD in the UK, and he is in the Constitutional Law Department in Bakırçay University, and we will now listen his presentation. And we would like to ask him to respect the time. Thank you very much. First of all, I would like to thank the audience who has stayed until this time of the day. It is very difficult to be in the last session, and it is more difficult to be the last speaker of the last session. And I believe the panelists before me did a very good job, and I won't be doing anything different. My presentation is about legal fees. And in Özge's presentation, in fact, the importance of these were mentioned, or the obstacles created by their presence was mentioned. When we talk about the supremacy of law, then there needs to be a physical access to a court. When we talk about this access, it is not only about having access to a court, but also having an effective judgment. And among the applicants, the possible obstacles need to be eliminated. And during the economical crisis, we have significant poverty, and legal fees create obstacles. And I have a plan in my presentation, what is the right to a trial, and then how do these fees create an obstacle, and under which circumstances they are legitimate. I will give examples from the judgments of the European Court of Human Rights, and then I will elaborate on the decisions of the Turkish courts, and I will then conclude. Let me briefly elaborate on access to justice at the domestic level. On the Article 36 of the Constitution, this is regulated. It is not about a dispute and taking this to the court, but it is about the execution of the judicial decision, because there are many administrative decisions that are not executed, and especially regarding the right to assembly, certain decisions have not been executed. And we see that the Constitution does not foresee any limitations. However, there are certain material limits, of course. In the European Convention on Human Rights, there is a jurisdiction that is defined by the Golder UK case. And then in the Hornsey Greece judgment, we see that there is the right of execution of decisions, and this is an important right in the context of the legal fees. So, in all the procedural interventions, there is a limitation. So, having a time limit for filing a case, and the obligation to be represented by a lawyer and paying certain fees to the court can all create obstacles. However, not all of these result in violations, and there is a margin of discretion created in Europe, but this shouldn't be harming the essence of the situation. And European Court of Human Rights talks about the negative obligations, meaning not to limit access to the court, and then also about positive obligations. And the state should eliminate certain economical obstacles in front of access to the court. When we talk about fees, what do we understand? And in the Roman law, we have certain entities. However, during the kingdoms, there is some interesting data. The kings were in charge of the litigation themselves, and during the Middle Ages, as the treasury got richer with the fees that were paid, the kingdoms, in essence, promoted going to the court. And the fees are the costs that are paid to cover the services. And legal fees are paid for making use of legal services. And Professor Ulaş talked about the services being pro bono, and in a social state, you shouldn't be paying any fees for the legal services. However, this is not valid today. And for Turkey, in societies that like going to the court, this will, having it pro bono, will increase the number of cases, and this will create the tendency to refrain from paying the taxes. Although it should be at a reasonable level, they are for paying fees. So how does the Constitutional Court approach the topic? And we see that the Constitutional Court says that the Constitution does not stipulate the pro bono delivery of legal services, so fees can be paid, and not paying any fee can hinder with the efficacy of the system, it says. And for the expedition of the services in the criminal procedures, there is the necessity to pay fees. In the past, they had refrained from having any fees, but then it says that the legislator has the discretion. For people who do not have the means to pay for the fees, there has to be an effective system in place. So this portion of Provision 13 is cancelled. And at the time, Judge Mehmet Erten says that for criminal procedures, obtaining fees ahead of time will harm the presumption of innocence, he says, and writes a dissent. And in the comparative law, as a model for a state of law, the administrative fees is not a violation of access to justice. However, if it creates an obstacle in front of people having access to court, then it has to be considered individually on the basis of each case. In 2008, in Germany, there was an amendment to the Social Security law, and until then, in the cases opened, there were no fees. And who goes to litigation? For example, people who are retired, who get social aid, and who have disabilities. So these groups are already disadvantaged, and bringing further fees will be violation of their rights. So how about the European Court of Human Rights? Kreutz Poland decision is an important decision in that regard, and this has reflections on the Turkish laws. There is an applicant and who had gone bankrupt, and this was a dispute about a fee paid to the municipality, and then he is asked to pay the court fees, and he was asked to pay the equivalent of an annual income, and his request for legal aid was also denied. And it says Article 6 does not bring any exemption from legal fees. But is this fees for the first-degree courts or the appellate courts? So the amount that is covered is important. In Turkey, we see two important decisions. Mehmet and Suna Yiğit decision. There is a malpractice for the descendants of the couple, and they want to file a case, and they have a poverty document obtained from an administrative office, but the court says that you are being represented by a lawyer, and if this is the case, you do not need legal assistance. And at that time, they were asked to pay 514 euros. It is about 7,000 to 8,000 Turkish liras calculated by today's exchange rate. And constitutional courts decides that as the justifications are not sufficient, and this amount is 4 times the minimum wage, there is a violation. Another judgment, as has been mentioned in the morning, and as something I remember very vividly, this was about the snow in Istanbul. There is a municipality of a new neighborhood, and that day, because of snow, the shuttle buses don't arrive. The kid wants to walk back home, however, freezes and dies. And the relevant documents are obtained, and administrative court denies the right to file a case, and the European Court says that you had to have something in place to protect the individuals. And Ülger Turkey is a judgment that is controversial. There is a worker and who works for a company in Russia and goes to court and wins the case. And the company will get bankrupt and they will run away, they say. And as the applicant did not pay the legal fees, and as this is regulated by Articles 28 and 32, the individual does not have the decision executed, and the company really declares bankruptcy and runs away. And European Court says that there is a real violation here, and as there is no exemption foreseen, the right to have access to the court is being violated. Until the legislative amendment takes place, some people apply to the superior courts, and in the Ministry of Justice, the judgment is cancelled, and they bring it to another court. Although no reference is made to European Court of Human Rights judgment, not executing the judgment is defined as a violation. They cancel Article 28 but not 32, and which stipulates that all services have a nominal fee attached. As the general provisions are there, the courts continue to handle the case, and legislator made an amendment and says that not paying the fee should not create an obstacle. And it is at least an objective implementation of European Court of Human Rights judgments. However, in practice, many courts have similar practices, And they say that as provision 32 is still valid, in certain chambers, the officers do not take this into account. There is an SP judgment. There is a citizen of Chechnya who wants to file a case against Russia, and his request for legal assistance is denied, and the Constitutional Court says that there is a categorical approach here, and the court was found to have violated the individual's rights. And Taceddin Ceylan is a business person, and this takes place in Batman. As he is represented with a lawyer, legal assistance request is denied. The individual pays the fee and then makes an individual application, and the court decides for violation. And there is a judgment by the European Court of Human Rights just last week. This is about the article I have previously covered, and it is brought to the Constitutional Court, and in the Constitution we see Article 46 being in place, and the parties had to litigate, and as you will be asking for legal fees, their ownership rights are being violated. It doesn't cancel the provision 32, and this is somewhat controversial. I want to remember one of our professors with this opportunity. And lastly, in the human rights procedural law, in individual applications, how are the legal fees covered? Tomorrow we have a whole session dedicated to this topic by our colleague Ezgi. At the Turkish Constitutional Court, in order to make an application, you have to pay a very high fee. And when you make an application, you have to attach the invoice to your application. And even the application is not confirmed, you still have to pay this fee. In Azerbaijani courts, on the other hand, for individual applications, no fee is requested. There is also a legal assistance mechanism in place if the individual provides concrete documents about poverty, and maybe the individual has some type of financial tool, however, he doesn't have the capacity to pay for it, then the individual is given 2 more weeks of an extension to pay the legal fees. And the Constitutional Courts, while making the identification for legal assistance, respects the principles, and if they check whether this individual has received any assistance at degree courts. And I guess I still have 1 or 2 minutes, and I'm going to conclude soon. And my German colleague Bockerman has 6 recommendations. So what can be done for these problems? Regarding certain social rights or social classes, there can be exemptions. And before the 12th of September, we were not getting any fees from workers. However, after 1980, this was amended, and for rent disputes, for example, tenants going to the court, and right to have shelter, those can be exempt from fees. However, when legal entities are going to the court, then there is again exemptions.
One is that when consumer go to court, then if the consumer is in a weak economic position, then there will be exemption from the fees. Then there is another law on the state water affairs. There is here an exemption here as well. This is important because water is a very important right in our day and age, and therefore then some cases may be simply removed from the necessity of lawyers. Fieldwork shows that reasons given are very general, and Duygu Hatipoğlu said she's an expert on this, said the opposite, but then, perhaps if there are domestic violence cases, there may be a possibility produced here. There's the Swedish model where outside of showing witnesses, there would be no fees or fees to be charged people according to taxes. Then, of course, there's a problem with tax justice in Turkey. I mean, the restaurants pay so little, the monthly revenue seems to be 30,000 lira. Then a kind of insurance is proposed for certain cases. From the point of view of the choice of lawyers on the part of the insurance, this was cancelled. And in practice, this is criticized very much. In Germany and Holland, there are opposite cases. Here, only rich people can go to court. This makes the court an instrument of the upper classes. So finally, I can finish in this following manner. Going to court is not unlimited. The barrier here is the fees, but in certain cases there may be exemption. And in our country, in recent times, there is this deep poverty, and there must be certain exemptions of the fees. Thank you for listening to me. If you have questions, of course, I would be very glad to answer them. Thank you. We thank all the speakers. Are there any questions? All three topics are very important. I congratulate all of you for these nice presentations. Yes, the microphone is too tired to come, has escaped from the meeting.
Ses.
Evet, tercümanların süresi dolacak.
Well, the interpreters are short of time, so please be short. I don't know whether this is a question or a comment, but I'm be telling the truth now. Well, you talked about this lack of law. This is an example in the world where we are really living in the darkness of the violation of law in our life. I am the chairperson of People with Disabilities, the Federation of People with Disabilities. I have a daughter who is struck by paralysis, but for 10 years now, the her rights have not been granted. And we showed hundreds of cases as precedent, but among these files, only 10 were taken into consideration. With respect to the burden, you cannot really go to court for both physical and moral compensation. The person works for 12 or 15 years. I was working for the metropolitan municipality and then I was laid off, so I say, give me my compensation. 25,000 was given, and this is going to go to all the fees that I pay for administrative courts, administrative authorities, and so the money 6 years later, you know, the foreign currency, I mean, the parity between the Turkish lira and the dollar and the euro was so different when I had asked for this compensation. Now, so let us take up all of these violations of law, and we lived through all these problems. This is a precedent. Well, if you're a social state, if you're a welfare state, you have to inoculate these people. I'm sorry. Hundreds of cases have not been accepted as precedents. Yes, I mean, they are indebted to you, and you owe them a debt in the end. That's really terrible, says the chairperson. Hello, my name is Mesut Yazıcı. Thank you for your presentations. I am doing my BA on sign language at Ankara University, MA, and I am a legal expert for Turkish Sign Language, and I am also translating for Arab Sign Language users. There was a translation studies conference last year, and we participated there. We made a presentation. The deaf the views of the people deaf who receive Turkish Sign Language service in Turkish courts. First, did you know the interpreter? We asked them, and they said yes. The second critical question was this: have you received any legal counseling from the interpreter? Now, this legal counseling thing obviously is very strange, because they don't receive legal counseling at a sufficient level from others. They receive from us some legal counseling. You know, do I say yes or do I say no to this question? Do I lose my rights? You know, there is a legal project. They call this project, and you know the number of this project, and they can receive legal counseling in another country. The interpreter hasn't heard which country. Can Turkey do this? Can it provide unpaid services to people hard of hearing? And my second question: in 2019, March 2019, there was another event organized by Atılım University and the Ankara Bar Association. They shared news articles saying that there will be unpaid services for the people with disabilities. Here, the facilitation that they're talking about, is this only finding interpreters, or will we do interpretation in the notary public? When we go there, someone is going to give a proxy document. If this person does not know how to read and write, they have to pay more. So they really pay for the disadvantage. I mean, it's like you pay more if you're disadvantaged. So for all disadvantaged groups, because I, am a sign language expert, I've talked on the deaf, but these fees perhaps can be waived for them. Well, your question, I mean, access to bar association, this is the question that arose in my mind. Qasim, can I throw the ball to you? Qasim is a counselor to the president of the Bar Associations, Union of Bar Associations of Turkey. Could you give us a brief answer?
So the fees for the consultancy, I could not really understand what that is, but I know that it is available in Ankara for persons with disabilities. There is a separate list for legal assistance, and assignments are made from there. Maybe this can be considered in detail, but it will be better if we talk in person. From 1992 to 1996, I worked at the Istanbul Bar Association, and the interpreters at the association were helping you, and these people were making calls to the Bar Association to assign lawyers. And from 1992 to 1996, we worked together with sign language experts. We were bringing together the lawyers and the interpreters did not provide any legal services, but they were just translating. And because of a need, the conversations with the lawyer were carried out in the presence of an interpreter. Then the files and the documents needed to be analyzed, and the interpreters had to work at that instance as well. And by that time, they had already learned about the details of the case, and they then would help with the testimonies. And so I do not know what happens now, but my daughter is a psychologist and a lawyer, and she attended sign language courses, and I do not know about the current political will. However, we have a project, and if the gentleman gets in touch, and this project of the Center for the Rights of People with Disabilities will help him to understand the details of the situation. So Qasim and our colleague will help you with your questions. Let us conclude, and those who have further questions can ask after we finish, and they can reach the individuals outside. Let us have a last question. I am a social worker. I am coming from the field. lately, and there is the Children's Protection Law, and there is the measure of consultancy. And in all the divorce decisions in Ankara, this authority is used, which brings a threat. The child is going through a trauma during the divorce, and counseling services is provided in the presence of trauma. But if you find this applicable to all the children, we have to see the child 8 times. And if the child does not have a trauma per se, seeing and counselor 8 times will create a trauma in itself. And there are people who are social workers, sociologists, who are giving this counseling. They are not necessarily psychologists, and this can create the risk of a trauma. So what do our colleagues think about this? As you said, this will create a trauma for children who are not experiencing a trauma. And also this limits the time allocated to children who really needs this service. And this also is creating a problem for those who deliver the service. I believe such a practice is not to the best interest of the child, if you ask my opinion. And I am working as a social worker in Ankara, and I completed 25 years of service. So in the Children's Protection Law, the decisions are very important for the protection of the children. And there might be problems regarding the practical dimension of things, and these can be discussed in a different platform. Yet, in the system required for protection, I believe all 5 decisions need to be practiced, not only the one about the counseling. So we can discuss the details during the breaks. Regarding the identification of the gentleman who took the floor, with the increasing inflation and currency rate changes and devaluation of the Turkish currency, the time the case is filed and the time the judgment is given, the time that elapses in between is quite long. And there are decisions saying that, and if you are to arrive at a judgment, that depreciation has to be taken into consideration, because in very long trials, the individuals might be losing. However, what they receive might be very low in value. So this was one of the reasons for cancellation, for example, in the previous cases I covered. As the value will depreciate, the individual's right to ownership will be harmed. And I skipped something as I was presenting. There is an insurance ad by the company Allianz, and for the legal insurance, it claims that rights require money. Right itself is not useful. So they are very explicitly talking about the need for an insurance. Thank you very much for listening once again. So we came to the end of the last session of the first day of our activity. I would like to thank all my colleagues, especially the speakers. Thank you very much. Hope to see you in tomorrow's sessions. Goodbye.
Unuttum, eksik bıraktım. Kusura bakmasınlar. İşaret dili tercümanlarına ve
I would like to thank our sign language interpreters and other interpreters who